Good afternoon and good morning, everyone. Thank you for attending today's webinar, Demystifying the Patent Process, the IP process with Sotomayor IP Consulting. The webinar today will be approximately 60 minutes. That will include some time for Q&A at the end of the session today. If you have questions, we encourage you to use the questions panel in the GoToWebinar console there on your screen. We'll get through as many questions as we can today. We will have contact information up at the end of the webinar in case we can't get to your question during the presentation. So this will be made as a recording, and it will be sent out to all registrants within 48 hours of the conclusion of this webinar. And we'll also have it up on our YouTube channel for Early Growth FS, for Early Growth Financial Services. My name is Jason Kennedy. I'm your moderator for today from EGFS. Our guest today is John Sotomayor. He's going to be our presenter for today. John, say hello.
Hey, hello everyone. Nice to be here.
Great. Tell us a little bit about what you guys are doing.
Thank you, Jason. I appreciate that. I'm really pleased to join you all today, and thank you also, Early Growth Financial Services, for hosting this webinar. As mentioned, I'm a patent attorney. I'm based in Research Triangle Park, North Carolina. Our firm specializes in assisting startup and emerging growth companies in how to protect their intellectual property. Prior to founding my own firm, I was in-house patent counsel for a couple of high-tech startups here in the Research Triangle Park, and a former patent examiner with the United States Patent Office. I spent the first part of my career as an engineer, working in utility, telecom, software, and intelligence sectors. But over the past couple of years, I've discovered that there are a lot of misconceptions about the patent process among entrepreneurs and innovators. And so we developed this presentation to help correct this. So with that, let's go ahead and get started.
Yeah, why don't we start with an overview and tell us a little bit about what all we're going to be going over today. Sure.
Today we identified 6 major areas in which we provide information to innovators and to entrepreneurs. The first is how you decide that something is patent eligible. So we provide some education on those types of things that you need to know before you move forward. The second is, once you know about patent eligibility, how do you move forward with something that you have invented? How do you know that something you've invented is patent eligible? So this is the discovery process. Next, many entrepreneurs have, and especially companies that are growing, have more than one single innovation. So how do you develop a patent strategy in protecting all of your intellectual property such that you can build a patent portfolio to protect all of your interests? The next step is actually prosecuting a patent application to completion. Now, once you've prepared something and sent it into the patent office, then there is a prosecution phase in which you negotiate with the patent office in terms of what the scope of your protection should be for your innovation. Next, what do you do about international patent protection? U.S. patent covers you geographically in the United States, and all of the countries have similar patent processes, but how do you enter into that particular environment? So we'll talk a little bit about the Patent Cooperation Treaty, which is the vehicle under which you would seek international patent protection. And finally, what is the successful conclusion, and some Q&A. So with that, we'll talk a little bit about how do you decide whether something is patent eligible. We want to talk about how you know it's patentable, what sort of patent hurdles that you have to get by, because the laws have changed since 2013 with the America Invents Act being enacted in 2013. So we want to talk a little bit about that. That has established a 12-month window, which is a safe harbor, and we'll talk about that with regard to public disclosure. Next, what about software patents? Is software eligible? We'll go through that in greater detail. What are the types of patents that are available, and what do you do about searching and the types of searches that are available in order for you to decide whether you have priority and whether you can move forward with your patenting your innovation. So by statute, an innovation is patent eligible if it is a process, if it's a machine, a manufactured item, a composition of matter such as a drug, or an improvement to any of these other categories. So these are the categories by statute under which you can seek patent protection for your innovation. But as I stated earlier, there are some hurdles that you must be aware of. The first is there are some things that are complete bars to moving forward with your innovation. The first is, has it been previously patented? During the prosecution phase, which we'll talk about later, the Patent Office is charged with making sure that you're not infringing on anything that has been already patented. So if something has been previously patented, it unfortunately is a complete bar against you moving forward with patenting your innovation, because a patent is defined as a right to keep others from making, using, selling, or importing your patented innovation. So if it has been previously patented, then there's no way that the United States can grant you that limited right monopoly. The second complete bar is if it has been previously disclosed by another. Again, you have the same rationale here. If it's been previously disclosed, then it's already out there, either being sold and used by others in a public sense or previously patented by somebody else. That being said, those are the complete bars. But there are some other hurdles that you need to be aware of, and these have to do with public disclosure. If you have publicly disclosed, you as the innovator, have publicly disclosed your innovation, the details of your innovation, by offering it for sale, by using it in public, by presenting the details of your innovation in a forum in which others are free to disseminate those details any way that they want. And these include lecturing at a university, for instance, or publishing something in a journal, or even talking about it openly on a street corner. Those are all considered public disclosure. Now, what is not public disclosure is if you have a closed-door meeting, either under a non-disclosure agreement or in a closed room with just a couple of investors, for instance, where you talk about the details of your innovation. That is not considered public disclosure. So what public disclosure does is it triggers a 12-month window under the American Invents Act, in which you have that 12 months to file for patent protection on your innovation. If you do not file for patent protection during that 12-month window, then your innovation is considered as being freely given to the public. And I can tell you, a patent examiner can and will use your public disclosure against your patent application to deny a patent. So these are the things you need to be aware of in terms of patent hurdles. So let's talk a little bit about types of patents out there. Many people know that utility patents those utility patents are usually the ones that people are talking about when they say they've got a patent. There are also design patents, which cover the look and feel of a particular innovation. There was a large case here a couple of years ago about Apple patenting the look and feel of the design of the iPhone case, which they successfully patented and successfully protected. But I will tell you that design patents have very limited utility, because all you have to do is just change one of the details of the design and it overcomes the patent. Plant patents are very specialized. There are only a small number of large companies that design and produce new plants, and they have a very, very limited use in terms of how many of these are granted each year. So plant patents are not something that we generally tend to deal with. However, in terms of utility patents, there are basically two varieties. Many times people will talk about getting a provisional patent application. And a provisional patent application it's simply a priority placeholder. It's sort of a stake in the sand, such that you put your stake in the sand and you have reserved yourself 12 months, because a provisional term lasts for 12 months. You preserved your right to file a non-provisional patent application on that innovation and maintain the priority date of the filing of the provisional. So you can get to the point where you're almost ready to disclose your innovation, have a few details left to work out, but you can file a provisional patent application and go out into the industry, do market surveys, do sales, do things like this, all under the umbrella of patent protection under patent pending without having to go through the prosecution phase. Then, before that 12 months are up, if you decide that you wish to move forward with a non-provisional patent application, then you file a non-provisional patent application. The primary difference between a provisional and a non-provisional is that a non-provisional patent application has a set of claims. Now, that's very important because claims are the only part of a patent application that are defensible in a court of law. So even though provisional patent applications may have claims, they don't need them. Patent claims in a provisional are never examined, and patent examiners only review claims that have been submitted in a non-provisional patent application. But the good part about it is, if you file a non-provisional patent application during the 12-month term of the provisional, then you can maintain and keep the priority date that you established with the provisional patent application. So it's a natural partnership going from a provisional application to a non-provisional, and that secures your rights during the entire term. So let's talk a little bit more about software patent eligibility. Because we have a lot of innovators in the United States who primarily are software engineers or software designers, software developers, I get a question a lot of times, is software actually patentable? Because there's been a lot of mistaken impression about software not being patentable due to some court cases that have been decided by the Supreme Court recently. In 2010, the Bilski case, and in 2014, the Alice case, and we'll talk a little bit more about those later. But as far as patent eligibility is concerned, by statute, things that cover laws of nature or natural phenomenon or abstract ideas are not patent eligible. So if you have a software package or module that has one computer talking to another computer such that there's no interaction with a human user, that is considered an abstract manipulation of data. And it's covered under the idea of abstract ideas, or the theory of abstract ideas. And so by statute, a computer talking to another computer is not patent eligible. So those software modules are going to be denied by statute. Well, you have a second category that we have discovered is software that is patent eligible, meaning it covers one of two things. There was spoke earlier about the Bilski decision by the Supreme Court. Well, the importance of the Bilski decision is that it provided a two-step test on how to know whether a process, and software is a process, is patent eligible. The first step is whether it creates a transformation of an article to a different state or thing. In other words, is there a transformative step? Primarily what that means is, does the software produce a product that a human being may make a decision or take an action upon? So it's such that it causes a transformative change from an article from one state to another state. And usually you have a human being that's involved in that, such that they can, like I said, make a decision or take an action. So if you have software that meets that step, or the second step is whether the software improves the performance or function of a particular device or apparatus. If you meet either one of these steps, then software as a process is patent eligible. Part of the problem is, because there's so much miscommunication about the software eligibility of patents, it takes software patents a lot longer to get through the patent office, because examiners look very, very carefully at software processes. So generally speaking, if you have created a software innovation, and I used to use the example of apps, although software apps these days, some of them have very long lifetimes, some of them have very short lifetimes. But if you have a piece of software that you can determine that the market is either going to wax or wane in a 2 to 5 year period, or you see that the total addressable market for this software application is really not that large, such that everybody who, wants it is probably going to acquire it within a 3-year time span. We call these short life cycle patents. And even though they are patent eligible, the problem is that because it takes so long for a software patent application to make its way through the patent office, you're not going to get that patent granted in time to do you any good in the marketplace. So generally speaking, we advise our clients that if you can determine that your software patent is going to have a market life that's fairly short cycle, then we advise our clients not to file for patent protection on those types of software processes, and instead keep the details of the software under wraps through trade secret. The third category of software, yes?
John, a real quick question we had come in around this,
Sure.
and I'll try to paraphrase, but does specific code or algorithms kind of fall under this umbrella, or is that even patentable? What does that look like normally, or what do you see from your side?
Right. Software algorithms that have been placed in a software implementation in and of themselves are not patent eligible. It is simply the result of the software algorithm, how it has created, like I said, something that's a transformation into a state or thing and upon which a human being may make a decision or take an action, such that you have a result that you can move forward with out in the real world, such as a recommendation. Those types of innovations are patentable, but simply putting an algorithm, creating a software implementation of an algorithm is not patent eligible by statute, because that also falls under the theory of an abstract manipulation of data. So algorithms themselves are not patent eligible when expressed in software, but the result, the reduction in practice of what that algorithm does, such that a human being can utilize it, actually is patent eligible. Does that answer the question?
Gotcha. Yeah, great. Thank you.
Great. So the final category of software innovations that we see are those innovations that you either bet your business on, or does improve the functioning or performance of a particular device or apparatus. These types of things that are going to last a long time or improve the functioning of a device are the software innovations that you definitely should file a patent application for, because these are the types of things that have the greatest impact in the marketplace. One of the examples that I used to give was a software app called Waze, W-A-Z-E. And initially, when it first came out 3 or 4 years ago, I thought, this is not going to last very long. But it was purchased by Google and incorporated into Google Maps. So now it has a lifespan that goes on certainly as long as Google Maps is going to be around. So that is something that, and I do not know if Google has filed for patent protection, although they are very active in filing for patent protection. But if they haven't, they probably should, because this is a good example of something that improves the performance or functioning of a piece of software that is utilized by human beings every day. So those types of things definitely should be filed for patent protection. So next I want to talk a little bit more about searches, because even though you may have something that is patent eligible in terms of a new innovation, how do you know whether it is useful, novel, and non-obvious? Is it new? Well, the only way, and the only good way to be able to determine that is if you search the existing patent literature. And we'll talk a little bit more about competitive landscape searches later, but just a simple patentability search permits you to go out and look and see what types of things are already out there that might be either keeping your innovation from being patented because it's already available, or provide you with a direction on where to go in order to move past what has already been patented. So a search is something that will help you determine that. And we we basically advise almost all of our clients that they need to do at least a patentability search in order to know how to move forward with their innovations. And I want to talk a little bit about timing expectations. We'll touch on this a little bit more. But the timing expectations from the official filing date can be pretty long-term in terms of software, or it can be fairly short cycle in terms of, let's say that you've invented a new golf ball. But regardless of what your innovation is, if it's something that's simpler to examine, such as a machine or a manufactured item, a toy, something like that, you're looking at probably 12 to 18 months before you'll get some sort of an office action from the patent office. And this is primarily because the patent office is usually overwhelmed with patent applications. Last year, there were 600,000 patent applications that were filed with the U.S. Patent Office, and there were about 250,000 patents granted. So you can see there's a big difference between how many are granted each year and how many are filed upon. So that has created a backlog in the patent office, and the biggest backlog has to do with software innovations. So I can tell you that if you have a software innovation, you're probably looking at anywhere from 24 to 32 months from the date of filing, the official filing date, before you'll see some sort of an action from an examiner. Now, I was an examiner at the patent office that did primarily software innovations, network computer systems, having to deal with all of the simulators and emulators that were being invented. And my docket was 200 patent applications deep. Now, since I could only work on about 4 or 5 per week due to the amount of time it takes to properly examine something, you can see that that 200 cases meant that I was not going to see a patent application until 12 to 16 months after the official filing date. And it can be considerably longer. So if you're going to move forward with a software innovation, just know that the time from the official filing date before you really get a granted patent application, and there are other reasons we'll talk about later, is 3 to 5 years. So just keep that in your head because it will be important. So that
John, another question that came in along those lines from someone here, is are you protected during that time period? Like once you get your initial application in, like what kind of what protections are afforded to you, or what does that look like, and what can someone who's seeking a patent for the first time expect?
Sure, great question. Whether you file for a provisional patent application or a non-provisional patent application, from the official filing date, you're protected under patent pending status. Now, what that means is you cannot take somebody to court until a patent has actually been granted because of the prosecution. The prosecution is what really gives you the official status as patented. But during the time of patent pending, that provides official notice to the public that you have applied for patent protection and that you intend, upon grant of your patent, to pursue those who have infringed upon your patent pending application. And the cool thing about that is that once a patent has been granted, you can seek, if you do go to court, you can seek compensation in the terms of all profits all the way back to the first date of infringement, or all the way back to the date of filing of your provisional or non-provisional application. So you are protected under patent pending status, and even though you can't move forward until your patent is actually granted, the patent pending status serves as public notice that you've already applied for a patent on this and that you are intending upon protecting your IP. So is that good?
Yeah, that's great. Thank you very much.
Excellent. Okay, so once we talked about patent eligibility, but let's talk a little bit more about how do you know if you've got something that you should file a patent application upon. As we said earlier, patent finding out if you have something that is innovative enough to move forward with a patent application is termed as patent discovery. And patent discovery, you have to keep in mind that a patent covers something that is useful, novel, or non-obvious. And not obvious. It's got to be all three. I apologize, it's not or. So we developed a couple of ways to help inventors because we get this question a lot. One of the first things we did is we'll talk about the wow, that's cool factor. Also talk a little bit about patentability opinions with regard to searches. Go into a little bit more in depth with regard to patentability searches. Identifying your risks and opportunities based upon what has been discovered as already being out there versus your innovation, and then talk a little bit then about preparing and filing a patent application. So is it patentable? Well, this is the standard you got to meet. Is it useful? Is it novel or new? Is it not obvious? It's pretty easy to figure out whether something's useful or not because many people create innovations as a result of not being able to find something to solve their problem that exists out in the marketplace. Many, many inventors feel some pain from not being able to solve to have a solution for their problem out in the marketplace, so they go and do it themselves. So generally speaking, you know when something's useful. Likewise with novelty. I mean, if you cannot find it out there anywhere, chances are pretty good that you can understand whether your innovation is novel or not. The real difficult thing is trying to discover whether your innovation is non-obvious. And there's a very good reason for this. The reason that the Patent Office looks at obviousness is because they don't want somebody to come out and find one piece from one patent, another piece from another patent, and a third piece from a European patent, and put them all together and say they've created something that's new. Because remember, what patents really cover is ideation and creation. There must be something that is a creative innovation that is part of the patent itself. That's what a patent actually covers. So the Patent Office is charged with guarding against infringement because the patent itself is a limited time right, as I said earlier, to keep others from making, using, selling, or importing your patented invention. So you have a limited monopoly for 20 years from the date of the official filing date to keep others from making, using, selling, or importing your innovation. And then at the end of that time, then your innovation is then considered being given freely to the public. So you're making this bargain with the government. They're going to give you a monopoly, but it's going to end. And at the end of that monopoly, then it's given freely to the public. So during that time, when you're covered under your patent, that gives you the runway, if you're a small company or a large company or whoever, that gives you the runway to get your innovation out into the marketplace and receive the benefit from your innovation. So this is why it's very important to know if something is useful, novel, and non-obvious. Well, a lot of times when you go through prosecution, patent examiners are charged with looking at innovations from the ordinary skill in the art standpoint. What I discovered with a lot of my scientists and engineers when I was serving as in-house counsel is that scientists and engineers think everything that they're doing is obvious because it's obvious to them. But the thing that I had to point out to all of them is that they are not people of ordinary skill in the art. They're very specialized. They're very highly experienced in their art. So I had to come up with some way to get across to them that how they needed to look at their innovations as whether they were patent eligible or not. So we developed this thing called the wow, that's cool factor. So I would tell my engineers and scientists, if you or someone on your team reviews a new process or item you've created, and you just sit there and think, wow, that's just cool. Since they are not people of ordinary skill in the art, that's something that should be investigated for patentability. And at my last in-house counsel engagement, we grew the patent portfolio from 8 patents to 23 patents over 3 years' time, utilizing this simple determination. So just when you create something, think about that. If you're thinking, wow, that's just cool, then that's something you should probably kick off a search for to see if it is patent eligible. There are certainly several different types of search options. All of the databases that have patent information, both here and in Japan and Europe, all over the world, these are public documents. So you can certainly do it yourself. Go out and look for any type of previous invention that covers what you're doing. Pardon me. You can also engage a search professional to go and locate everything that may be of importance to your particular innovation. Now, by search professional, I mean one of the biggest ones is LegalZoom. And you can certainly use LegalZoom. They'll do a good search for you. The problem is what they'll do is they'll send you back a book that's about 100 pages thick on everything they found, because they're basically doing a keyword search on everything they found that's relevant. And unfortunately, you're the one that has to go through and decipher whether it's relevant or not to your innovation. The third methodology is going and using the services of an intellectual property attorney. Now, the advantage of that is that an intellectual property attorney will also provide you not only with what was found that's relevant, but also an opinion as to how much relevance that has to your innovation, primarily through analyzing the claims and the disclosure in the discovered prior art, with an eye toward identifying the risks and opportunities that you face. Now, by risks, I mean those aspects of your innovation that may already be out there in some form. Now, it may not be exactly what you've done. I mean, otherwise there wouldn't be 500 different patents on golf balls. But it may permit you with the steps to find a way around what has already been patented and provide you with the opportunities on how you can move forward with patent protection on your innovation. And then once you've identified these risks and opportunities provided in the patentability opinion, then you can prepare and file a patent application that will not only give you the greatest ability for successful prosecution, but also be the strongest protection for your innovation. Okay, so we talked a little bit about patent eligibility. We talked a little bit about the patent discovery process. But many companies that I deal with have more than one innovation because they've got several creative people that are working for the company. So the next thing is, how do we look at building a patent portfolio? How do we develop a patent strategy to go from a single picket in a fence, which is what one patent is, to multiple pickets in a fence, which is what a patent portfolio will do for you? So in developing a patent strategy, we want to broaden out our idea of a search into something called a competitive landscape search, and we'll talk about that a little bit. Part of this is also a more in-depth analysis of your ideas against what's in the prior art, and then you can utilize this information to strategize such that you can minimize risks and opportunities for an entire portfolio, and then talk about a little bit more about the mindset that you should have when preparing and filing patent applications. So a competitive landscape search is a search that doesn't just look for your innovation, but looks at all of the competitors or all of the other devices that are similar or processes that are similar to your innovation, and identifies how all of these things from your various competitors are the same or different from your innovation. What this does is not just simply looking at how to make your single patent stronger, but also to look at everything that all of your competitors are doing, such that you can see what area in the marketplace is best for you to move toward. And the competitive landscape search actually does this quite well. One of the other things that we do with the competitive landscape search is that we have provided these documents to companies for their due diligence process whenever they've gone to talk to VCs. And in one case, it was part of the due diligence package when one of my clients was acquired by a much larger firm. So we went and looked at, we found 14 different competitors and there were 38 different patents, and we provided an analysis for all of this such that their patent portfolio, they could identify how strong their patent portfolio was with regard to all of the competition in their particular market. So it's a much broader type of and comprehensive type of search. Then once you have identified all of these things, then we're analyzing your ideas. And these are before you have committed these to any sort of formal application process. But I analyze all of the ideas for a multitude of risks and opportunities, because again, at this point in time, we're taking a step back and we're looking at building a larger structure, not just one single patent, but perhaps many patents that can cover an entire industry segment in which you can then have a very strong patent portfolio. So this provides a broader view of risks and opportunities for a portfolio as opposed to a single patent. Basically, from that, you can develop your patent strategy to minimize the risks. Where, over here, let's say you're doing something in augmented reality. Over here you've got a lot of companies that are dealing with games having augmented reality. But what if over here you have decided to build augmented reality or software innovations that deal with robotics or children or whatever? But that's very different from this other segment. So now you have an opportunity then to maximize your presence in a different market segment from where everybody else is playing. So this provides you an opportunity to, I'm not saying that you can corner the market, but it would certainly provide you an opportunity to develop an expertise in a market segment in which nobody else is playing. So it can be very powerful. The other thing that I want everybody to understand, if there are any concepts or ideas in this presentation that stick with you, there are two that I really think, excuse me, need to be the most important. The first is when you look at your innovation, you have to know whether it's non-obvious or not. That's one of the big ones. But the second one is you want to think about your innovation 12 to 18 months out from your current iteration on your product or innovation. And the reason for this is every inventor I've ever spoken to, because they are creative individuals, they not only have the product that they've currently built or software application, whatever, but they also have in mind what they're going to do to improve it in the future. So if you already have some inkling of how you're going to improve it, then you want to disclose that at the same time in your patent application. So you want to think 12 to 18 months out from your current innovation and put all of that information into the specification of your patent application at this point in time, because it takes long enough to get through the patent office that by the time it makes it through, you're going to be at that level of your technology or your innovation. So if you can think 12 to 18 months out, put those types of ideas and improvements into your description of your innovation when you file your patent application. Again, that's really, really an important idea that I would like everybody to take from this particular presentation. I've had more than one litigator lament to me that they wished that their client had thought 12 months out, because they were having to defend a patent in court, that the improvements were really the differentiator. So just keep that in mind. Okay, so we've talked about patent eligibility, discovery. We talked a little bit about developing a patent strategy for a portfolio. The next step is, and I call it negotiation because that's really what it is. Once you file the patent application, you know, 12, 20 months later, and depending upon what the innovation is, you're going to get some communication back from the patent office, from somebody like what I was, a patent examiner, where the patent examiner will provide their objections and rejections to your claims. Again, patent examiners only focus on claims. So they're going to look at the objections and rejections to your claims and provide you with their idea of how you should be moving forward, because the claims are all about the scope of your innovation. Now, as an inventor, you want very broad scope. You want something that's going to encompass everything that your innovation does, plus all of the equivalents and every other way you can think of to keep others out of competing with you. But what the patent examiner wants is very narrow scope, because remember, they're charged with guarding against infringement. So the narrower the scope, the easier it is for them to say that, yes, this patent is strong because there's nothing else out there that would infringe on this little tiny bit of scope. So you start out with very, very broad claim scope, send it to the patent examiner, they provide objections and rejections. You update your claims because claims are fully malleable. So you can amend the claim and say, Mr. Examiner, this is what I meant. So you decrease your scope a little bit, send it back in. They increase their scope a little bit. So this going back and forth, it happens on a 6-month cycle. 3 months for them, 3 months for you. But at the end of the day, what you'll wind up with is claim scope that is broad enough that it covers the innovation, but narrow enough that it doesn't infringe on anything else out there that the patent examiner has discovered. The good thing about this type of negotiation is that if you start with very broad claim scope, you're not leaving anything on the table as you go through this negotiation process. So this negotiation actually can provide you with the strongest patent claim coverage that you could get, other than, rather than just throwing it out there in a very narrow scope basis and getting a patent through very, very quickly, but a patent where the claim scope is so narrow that it's not really very valuable in the marketplace. So this process of negotiation is very important, and that's the prosecution phase. So let's talk a little bit more here about international IP protection. Patents are geographically bound. Once again, if you have a U.S. patent, then it covers you in the United States. However, you may have created some innovation that would sell well in Europe or Japan or Australia, South America, wherever. But the problem is that you have to enter into all of those countries separately. Well, all of the countries got together and came up with the Patent Cooperation Treaty to try and harmonize and make this particular process more straightforward. The Patent Cooperation Treaty is basically a treaty that permits an innovator who files in one signatory country first, but preserves the right to file for up to 30 months in all of the signatory countries. The PCT filing is accepted currently by 148 countries who are all signatories to the treaty, and every country sets its own expectation on whether public disclosure limits the right to file for patent protection. So you must file prior to public disclosure, for example, to preserve your rights in Europe and some other countries. Whereas, as we spoke of earlier, in the United States, once you publicly disclose your innovation, you have up to 12 months to file for patent protection. So we have a safe harbor. In Europe, there is no safe harbor. The moment you publicly disclose something, if you have not already filed for patent protection, then you lose your right to do so. However, the PCT recognizes that filing in a country preserves your entry and right into filing in all the signatory countries as long as you file for your PCT rights at the same time. Um, so the PCT is filed in two phases. The first phase is filing a demand for an international search. And this international search is good in all 148 signatory countries, and basically um, permits the searching authority, and there are several of them, permits the searching authority to provide all of the prior art that is discovered to any of the signatory countries, such that if you do file in another country, let's say you file in France or Germany, then that search will be accepted by France or Germany as the starting point for prosecution. So it saves you some time. It also preserves your right. It is a bit expensive. The search itself is usually about $2,000. And that's in addition to the time that it takes to actually prepare and file the demand for the PCT. So generally speaking, it can be fairly expensive. The second phase for the PCT adds more expense, unfortunately, because that's the entry into the national stage in countries that you have selected to move forward in. And by that I mean, even though you've preserved your rights to file with 148 signatory countries, you don't have to file in all of them. You may select any or several countries in which you can enter into the national stage simply by filing a national stage demand. And then the PCT, which is governed by the World Intellectual Property Organization, the World Intellectual Property Organization will provide the international search to the countries into which you have filed your second phase demand. So it's actually a fairly smooth process, but there are some things you need to understand. Is that when you file in the United States, whether it's provisional or non-provisional, that's the time when you need to be filing the PCT also in order to preserve your rights to file internationally. Okay, so we talked about whether something is patent eligible, how do you know if you've got something that's patentable, developing patent strategy for a patent portfolio, talked about prosecution and negotiation between you and the patent office, touch base on PCT international IP protection. So if you get through all of this and manage to do this in all of the in the proper timing and proper steps, then generally speaking, you'll get to the point where you are successful in getting a patent. So at this point in time, that's the end of my basic presentation, and I'd be more than happy to answer any questions. I'm going to bring up the next slide, which provides you with my contact information. But at this point in time, please let me know what questions you might have.
Awesome. Thank you very much, John. Just a reminder, everyone, you can use the questions panel in your GoToWebinar console to submit questions. We've got a few to go through already. And what we can't get through today, of course, you've got John's information there, and you're welcome to reach out with any follow-up afterwards. John, one of the first questions that came in kind of plays into the last topic you spoke to at the international level, which is we talked a little bit, I think, mostly about U.S. companies looking abroad, but what about foreign companies that have like European patents secured and they're wanting to come into the United States? Is that, I mean, is a U.S. patent off the table since there's a public disclosure there, or what does that typically look like?
Well, there are two phases to this answer. The first is if the European inventor or the inventor outside of this country has filed a PCT demand at the same time that they filed their let's say French filed their French application, then they preserve the right in the United States as well. The other thing is because we do have the 12-month safe harbor, if the European patent was filed less than 12 months from the time that they file a U.S. patent in the U.S. national stage, then they're still protected under the U.S. safe harbor as well. So if there's a European inventor and they file in France, let's say in December, and then they file in the United States in March of the following year, they're still within that 12-month period, even though they haven't filed with the PCT, so that they are protected under the safe harbor public disclosure in U.S. patent law. Like I said, the second idea would be to file for the PCT protection at the same time, in which case they would have 30 months, up to 30 months, to file for the national stage in the United States as well.
Great. Another question came in, sounds like a delicious one. How would one go about protecting a recipe? Are recipes eligible for patent protection? Have you seen or worked with anything like that in the past?
Yeah, actually I have. Unfortunately, a recipe is specifically precluded from patent protection because recipes are considered, under legal theory, recipes are considered sort of like a performance. So you can protect the actual recipe itself once you write it down, either on paper or on a web page or wherever. You can protect that implementation under copyright law, because a copyright is an original work of authorship that is captured in a tangible medium of expression. And that can, like I said, that can be a web page, it can be a book, it can be just a written textual recipe. So copyright law covers the physical manifestation, but the actual performance of that recipe, like I said, is considered performance art, and that's not really covered under patent law. So even though you can protect the physical manifestation and sell your recipes in a book, you can't actually protect the recipe itself against other people making and using the product that is a result of the recipe. So unfortunately, no, it's not eligible for patent coverage.
Gotcha. Great, great. So I've had a couple people come in with questions about just budgeting. Like, what does a typical startup founder, early stage founder, if they've got, let's just say, a single patent that they're wanting to start with, soup to nuts, what are they looking at spending typically on something like that?
Well, I got to tell you, Jason, that's a very difficult question to answer, because it's different depending upon where you are, what you're intending to cover, and how long the prosecution might be. Like, software innovations are going to cost more than a simple mechanical device, for instance, because it takes longer to get through the patent office, and it takes more time to actually prepare the application. However, I will say that a ballpark, now there are two different costs that you need to think about. Ballparks for searches, like if you want to do a simple patentability search, a simple patentability search should run you in the neighborhood of $1,000 to $3,000. And again, that depends upon how thorough you want to be and about how much time it takes to do it. Now, when I say that, I mean I'm talking about a patentability search that also includes a patentability opinion, not the $4.95 search that you get from LegalZoom or whatever the cost is these days. I don't really know. The problem, as I said before, with a type of LegalZoom search is that you've got to do all the analysis yourself. And I can guarantee you that this is a difficult enough process that deciding how a particular reference applies to you or not takes some expertise. So searches, $1,000 to $3,000. Soup to nuts, a patent application can cost as little, and we're talking about the preparation, the filing, the prosecution over a couple of years' time. Soup to nuts can be as little as $15,000 in some areas, or as much as $30,000 if you're in someplace like Boston or Silicon Valley. Pharmaceutical patents can cost considerably more. I dealt with one inventor who worked for a large pharmaceutical company where his patent application prosecuted by this large pharmaceutical company cost over $100,000. That's not going to be the common cost for a solo inventor or a small company. But in terms of budgeting, you should probably budget a minimum of $12,000 to $15,000 to get all through the process.
Great, great. We very early on in the presentation, you mentioned about public disclosure, and something that wasn't covered, didn't fall under public disclosure, was of course investor pitches, like being in a room with a couple of VCs, that sort of thing.
Right.
But what about similar events like public pitch events, or if you're an accelerator program and you've got a demo day coming up or something like that? Does if you have to stand up there and reveal the secret sauce, does that count as public disclosure, or do you need to just kind of throw up question marks like when it comes time to speak to that particular piece? What do you recommend there off the cuff?
Yeah, the short answer is that if you do disclose the secret sauce, the details of your innovation, yes, that is considered public disclosure. So when we have clients that are going toward a demo day or something like that, what we try and do is get them to file a provisional patent application. Now, the numbers I gave before were for a non-provisional patent application. A provisional patent application can be considerably less expensive, between $1,500 and $4,000, and that's to prepare, prosecute, and file. So we ask our innovators who are going toward a demo day or something like that, some pitch event, to at least put in place a provisional patent application, which then gives them full patent pending protection over anything that they want to disclose. Now, that being said, if you don't want to move in that direction, then we advise our clients who take this course of action, don't reveal the secret sauce. Talk about it from a 30,000-foot level, and tell those investors or those individuals who want more details that they will talk with them later in a closed door meeting, and then you can disclose the secret sauce if you want to, because you're in a closed door meeting under and you need to tell them, either sign an NDA, although most VCs will not sign an NDA, but as long as you say this is confidential information and you disclose it behind closed doors, that's not considered public disclosure.
Great, and that's something from our side, on the accounting and finance side, that is something that we see as well, that I'll throw out there, that for founders and entrepreneurs, that you're walking into pitch meetings with NDA documentation, you might as well just leave it at home.
Yeah.
VCs, investors are typically just going to flat out refuse to sign it. So just a little footnote there as well. Let's round out. One question I like to ask on these type of webinars, and we'll kind of round it up with this one, is what are the common mistakes? Like what are the pitfalls that you see entrepreneurs fall in again and again when it comes to IP protection?
And that's a great question. That's a great question, Jason. The primary one that I see most often is an inventor talking to a small group of people they're outside of a closed room, but there may be only 4 or 5 people, but they're talking to a small group of people, and they get so excited about what they're talking about, they just start talking about the details of their innovation. Now, even though that is a small group of people, the problem is these people are unfettered from any constraints on disclosure when they leave that group. So what happens is the inventor hasn't realized that right there they have fallen into the trap of public disclosure, and because they're not cognizant of that, 6 months go by before they start to think about patent protection, and they've cut their safe harbor in half without even realizing it. Now, it takes time from the time that you want to start filing a patent application. It takes time to write it, and it takes time to file it. So it can take anywhere from 6 to 10 weeks to get through the disclosure, get through the however many drafts it takes, and file this thing. So if you haven't realized that you've publicly disclosed your innovation, you can get to the end of your safe harbor without realizing it. The second thing that I see is individuals who do have some idea that they want to move into international patent protection, and they forget to file a PCT at the same time that they're filing their U.S. application. And so what happens is that blows their chances for filing for patent protection in Europe.
Wow.
You know, the other misconception that I've seen a lot is people writing things down in a notebook and mailing it to themselves and thinking that this will preserve their idea. That has no legal effect whatsoever. So please don't do that.
So that's been kind of a trope of sorts for years and years. Was that ever enforceable, or is that just something that someone in Hollywood cooked up for like a TV show?
Well, it was enforceable probably 50 years ago, but the patent laws have changed so much. Like I said, the latest innovation in patent law was the America Invents Act, specifically precludes you from doing that. So yeah, really at this point in time, it's just a trope. You know, please don't do it. It doesn't give you any legal protection at all, because even though you mail it to yourself and you don't open it, you don't know who had access to it or might have opened it on the way.
Right. Very good point. Great. I think we'll wrap it up there. We're just a shade over the hour. So, John, thank you very much for joining us today. This was fantastic. This super informative. As a reminder to everyone, this recording will be made available. You get an email within 48 hours. We'll also have it up on our YouTube channel within 48 hours, so you can review at your leisure as you need. And of course, John's information is there on the screen if you have questions that we didn't get to, or something that pops in your head immediately after, which is always the way. So you can reach out to John directly. And John, go ahead.
I just want to say a very big thank you, Jason, for hosting this, and also thank you for the kind attention of everybody who participated in the webinar. Thanks.
Yeah, that's great, and I think that's a good ending note. Everyone have a great afternoon and a great rest of their week.
Take care.